So we have completed section 10 of the Financial Institution Recovery Ordinance along with subsections 13, including the amendment which has been made in the Act 2016, and that has been mentioned as section 5 in the Act 2016. So today we are going to have some case law on section 10, so that will help you while you are filing a leave to defend application in a banking matter. So documents attached with the print, kindly take out, have your copy and pen to write this case law which I am referring you, or inshallah we will discuss on that also. There are 5 case laws which we are discussing today, and take out your copies and pens so you may write in the end of that. So documents attached with the plaint showed that the suit was completely filed. No substantial question of law and fact was raised by the defendant in their application for leave to defend that required recording of evidence for which leave was necessary. Defendant has also admitted their liability and no case for leave was made out. Application was dismissed in circumstances. So the case law is 2012. Kindly write down 2012 CLD page 189, Karachi. So in this case law, this case law supports the plaintiff. When you file leave to defend application, you have to consider the main ingredients. If you don't follow the main ingredients which have been mentioned in subsection of section 10, like if you haven't given substantial question of law and facts, if you miss that substantial question of law and facts while you are drafting your leave to defend application, on the basis of which the evidence has to be recorded. So that is the main important point, that in the leave to defend application you have to file substantial question of law and facts. And substantial question of law and facts, what are those? Those are issues. When we in order 14 CPC, we file issues, we draft issues. So those issues are in this banking ordinance. We say substantial question of law and fact. So this term is just for understanding that like issue, we file issue in suit in CPC. Likewise, we file substantial question of law and facts in leave to defend application. While we are drafting leave to defend application, it is very necessary to file substantial question of law and facts. On the basis of that, evidence would be recorded. So if the defendant has admitted his liability, if when you file leave to defend application, you have to file section 10 subclause 4. Section 10 subclause 4, what does it say? It says that you have to give a breakup. You have to give a breakup, that how much amount you have availed, how much amount you have paid, and what is the outstanding amount and what is the disputed amount. If you admitted the liability, that this liability is on you, so on that point your leave to defend will be rejected, because when there is admission in written statement, you have learned in CPC, when there is an admission in written statement, to that extent the suit can be decreed. To that extent the leave conditional leave may be granted, that the dispute on the disputed amount you record evidence, and what amount you have admitted, on that amount you have to deposit that amount in the bank. So have you written that? Hope you have written. 2012 CLD page 189 Karachi. Now, mode or manner of filing of a statement of account not provided in section 9(2) and 10 of the Financial Institution Recovery Ordinance. Filing of a statement of account was a matter of procedural formality, as no consequences were provided for familiar or strict compliance of section 9(2) of the Financial Institution Recovery Ordinance 2001. Application was dismissed. Principle. The case law is 2008 CLD page 778 Karachi. Kindly write down 2008 CLD page 778 Karachi. In this case law, if you raise objection that this statement of account has not been filed, a certified statement of account has not been filed by a financial institution. So when you are filing suit as per section 9(2) of the Financial Institution Recovery Ordinance, there are two points. One, in 9(3) you are filing a breakup. What that breakup means? That breakup which you are filing is how much amount the defendant has availed, how much amount the defendant has repaid, what is the markup, what is the other charges, and what amount is outstanding. So likewise, in if you haven't filed a statement of account, a certified statement of account along with your plaint, so that plaint cannot be rejected, because it is just a formality and it is held in 2008 CLD page 778 Karachi. So moving forward, when defendant, despite service in terms of section 9(5) of the Financial Institution Recovery Ordinance 2001, did not come forward and file leave to defend application, or otherwise failed to obtain from banking court leave to defend the suit, then the allegation of fact in the plaint are deemed to be admitted. Resultantly, banking court in such or pass decree in favor of bank. 2013 CLD page 534 Karachi. 2013 CLD page 534 Karachi. So in this case law, it is about a decree in favor of bank, and it is about if the admission, if the defendant has admitted the amount which he has availed and which he has not repaid, then the banking court in such a way pass a decree against the defendant. Another case law, defendant had neither denied his service on through publication nor alleged same to be invalid, neither choice of defendant would prevail, nor would he LL.B, nor he would he for prescribed more. Defendant, despite of his service through publication, has filed leave to defend application beyond prescribed period of limitation. High Court dismissed leave application for being time barred. So there is a mandatory provision in in section 10 2 that leave to defend application has to be filed. Leave to defend application has to be filed within 30 days. So if the leave to defend application is rejected on the ground of time bar, as it has taken place in this case, in appeal also, the High Court has dismissed the leave to defend on the ground being time barred. So case law is 2011 CLD page 1721. 2011 CLD page 1721 Karachi. All these case laws are of our Karachi High Court. Application for leave to defend were dismissed and suit was decreed. Contention of defendant was that the plaintiff bank has charged markup beyond the date of expiry of finance facility. Held that plaintiff bank could not charge markup beyond expiry date of finance facility. High Court modified decree amount by disallowing markup charged beyond the date of expiry of finance facility. Appeal was allowed accordingly. So please write down the case law 2014 CLD page 1436. 2014 CLD page 1436. In this case law, it is held that if in leave to defend application you have disputed the amount that the financial institution is charging markup beyond expiry date. So what is the beyond expiry date? A loan is sanctioned, let's suppose a loan is sanctioned for 3 years. So the financial institution can charge only markup up to 3 years, not beyond 3 years. So the High Court has held, and the decree that has been passed by the banking court was modified to the extent of markup that the defendant has to pay markup up to the contractual period. The markup has to be paid by the defendant up to the contractual period. Appellant bank, despite of service through publication, did not approach the trial court to obtain copy of plaint, enabling same to file for leave to defend the suit within the stipulated time. Failure of appellant bank to obtain leave to defend the suit as required under law, no option with trial court but to decree the suit based on averment made in the plaint in terms of section 9(4) of the Financial Institution Recovery Ordinance. No illegality was committed by banking court, which would be take care of appeal was dismissed in circumstances. 2015 CLD page 795 Karachi.